All right, y'all. So we are about 10 minutes away from the up. OBS already starting to. It's already starting to act up, y'all. Changed the settings on this OBS yesterday, hoping that we could avoid these crazy problems with OBS. Anyway, so we are about 10 minutes away from the status hearing. I think that's gonna be here. So in the meantime, what we will do is just talk about a few things that we expect to be coming up today. I made a video about this morning. Maybe we should just go ahead and play that. And because this is going to set us up for what we expect to come up today. I'm going to just play this video. I can watch myself. I can watch myself today. According to Thugger Daily's post from yesterday, Judge Whitaker is going to be holding a status conference for the YSL case tomorrow, which is today now. And the purpose of the conference is determine the next steps in the case. So a lot of people are wondering what exactly is going to happen today. So we came up with at least 4 different things that could happen. He was on the infamous Sylvia show yesterday, and she did a great job, as always, asking him a ton of questions and getting a sense for what's really going on. So the first thing a lot of people are wondering is, would there be a mistrial declared today? Max Sharp said that nobody knows what's going to happen. So first of all, the lawyers don't know what's going to happen. They have to be there. They have to show up, but they don't know actually what is going to take place during this meeting. But he did say that the defendants will not be there. So Young Thug, Shannon, all of the defendants, they won't be there. So Sharp said that there really is kind of a limited amount of things that could actually happen without the defendants actually in the room.
Next question is, can the case be dismissed tomorrow if a motion is filed?
That is always a possibility. Hope springs eternal, but I have a feeling that tomorrow is going to be more procedural and scheduling than anything else, mainly because none of the quote-unquote defendants are going to be present, so that really limits what can be handled and discussed.
Yeah, they're not even going to take care of the motions, right?
No, I mean, I don't want to speak for the court, but you can't do a lot without. I mean, that's the whole issue with the ex parte meeting. Is
be probably a lot of scheduling type of decisions made today. They have to get the case going again. They have to put it back on everybody's schedule.
And so I have court.
So y'all, what we're doing right now, we're just watching a video that I made this morning about what's going to happen today. All right, so we're just leading into the meeting, which should be starting in a few minutes.
9 o'clock, I'm going to have to see what I can get done there, and then I'm going to make sure I'm in court at 11:30. But I'm not in the know about exactly what's going to happen. I assume it's going to be scheduling matters.
Have you ever had a case with her before?
Judge Whitaker?
Yeah.
Yes. I've had many cases. I like Judge Whitaker a lot.
So that looks like one of the things that'll probably take place today. And by the way, we do expect this whole hearing to be broadcast, so everybody's going to be tuning in to see exactly what happens. But Sharp says he does expect, or he could predict, that scheduling will probably be part of what's going to happen. Another thing people are wondering is, might there be some kind of bond hearing, or might someone maybe request a bond, get a bond granted? I was looking at Kayla Bumpus, and she said that typically with bonds, when you request a bond, the state has 10 days to respond to your bond request. So she seemed to doubt that that's something you could just go in and request and have granted the first day. But they could possibly make the request today. And in fact, just yesterday, there was a bond request for Marquavius Huey. He filed a renewed motion for bond based on a change in circumstance. And of course, the change in circumstance is that all of this has happened. The case has been has been put on hold. You've had a judge removed. You've had little Woody take the stand, plead the fifth, go to jail, etc., etc. So Marquavius has requested a bond based on the change in circumstance, as reported here by Joseph Pop. I think he's actually going to court every day. So shout out to him and thank him for the information. So definitely looks like bonds will probably be requested, and who knows if they will be granted today. That's really the big question, but requested is likely. Recusal of Whitaker. Now this is another thing that y'all, Max Sharp yesterday, he floated the idea that Whitaker. Now, before I say this, he did not say he had any idea that this is going to happen, that he believes is going to happen, that he has any kind of insider information, which I'm going to say on the video. But Max Sharp just floated this idea that maybe Whitaker will recuse. I don't know. That doesn't seem very likely that she's going to call a hearing to say, hey, y'all, just to let you know I'm out, you know. But I thought that was interesting as well. That Max Sharp floated. Now, he was clear, very clear to say he doesn't have any information to believe that Judge Whitaker will recuse herself, that he's not speaking on kind of any inside information or anything like that. But he just floated the idea that because they don't know what's actually going to happen today, even the situation where Judge Whitaker has a conversation about or takes any kind of information from people, from the prosecutor, from the defense about her own recusal.
The state's table right now, and some of the defense attorneys, if y'all would not mind introducing yourselves and tell me who you are representing. And at least for the first part of all of this, I'm going to ask that y'all use your name tags to help me. I think y'all had at one point like placards that you could sit in front of you. We'll find them if they're, I mean, it's fine for now, but, and I know you, Mr. Short, but.
Good morning, Judge.
Good morning.
I'm going to get those out.
Yeah, I mean, we don't have to do it right now. I'm just saying, as we move, you know, for the first couple of weeks at least, if y'all don't mind doing that for me. So, introductions.
Judge, Max Sharp, I represent Shannon Stillwell. My co-counsel is Mr. David Boss, who is also here, and this is next to me. This is Shaquille Kokomo. He has been working on the audio visual on behalf of some of the clients, including Mr. Stillwell. So he's been a big part of this case as well.
All right.
Shaquille Kokomo.
Are you an attorney or paralegal?
He's going to be a law school student.
Okay. Well,
he's college graduate right now.
Fabulous. Good luck to you. All right. Thank you.
Good morning, Judge.
Good morning.
Carrington Matthews Sr. in this case. I also have also representing Mr. Marquavius, who is my son, Carrington Matthews Jr., who is not here today, and also attorney Teresa Mahfoud.
Anybody want to make a prediction about what you think is going to happen today?
Okay. And I had both of your names. I don't know if I have Miss Mahfoud's. Has she entered an appearance? Okay. All right. Well, we can update that. Okay. Thank you.
You're welcome, Robert. Thank you.
Hey, Mr. Butts.
David Butts, Shannon Stillwell.
Good morning, Your Honor.
Doug Weinstein. I represent Mr. Diamante Kendrick,
Okay.
along with my co-counsel Jay Apt, who's ill today, and Katie Hegarty, who's on leave right now.
Okay. All right. Hopefully, Mr. Apt will be feeling better
Thank you.
soon. You can pass that along to him.
I'll do that.
All right.
Good morning, Your Honor.
Morning.
I am Brian Steele, and I have the honor of representing Mr. Jeffrey Williams, along with the Honorable Keith Adams. Sitting next to Mr. Adams is a law student. He's a rising second year, John Marshall Law School. His name is Griffin Lail, Griffin-Lail. If it's okay for him to sit with us, it would be appreciated. If not, he will obviously.
Is he sworn in under like the Third Year Practice Act or?
No.
All right, so I guess he can just act as a paralegal for now. Okay, good to have you.
Good morning, Your Honor.
Good morning.
Leah Oblosky here for Mr. Rebellious Ryan. I am the second chair to Ms. Angela D. Williams, who is ill today. I think she's expecting a Zoom link.
She should be on Zoom, and I guess I should get on the Zoom as well. Give me a second to do that. Okay.
She is the lead counsel. I am the second for
All right. Ms. Rosser or Ms. Persfield, will I find a Zoom link on my calendar or? Okay. Give me a second to get on there.
So, Anthony, you feel the judge should rule in favor of the defense? I think that's what everybody watching is hoping will happen.
We came and tested everything yesterday, but of course the computer is not wanting to cooperate. Can I just go through Zoom for it? Trying to.
All right, y'all. Well, I guess while the judges, sounds like everything's on mute for a moment. So, let's get some predictions, y'all. Come on. Anthony says the judge should rule in favor of defense. I certainly agree with that. Hopefully, depending on what they're asking for. I mean, this is one of the crazy things that we talked about yesterday. The defense might ask
I'm not seeing her on the screen.
Oh, Your Honor, I'm here.
Okay, are you just not on video with us?
Right, but I'm here.
Okay, all right, well, good to have you. Hope you feel better. If you might be sick as well, I think. Okay. Good morning.
Old Westmoreland, Lamar Gardner, on behalf of Marcus Nichols. And we have one additional paralegal, not paralegal, intern, here this morning, if necessary, we'll introduce you to him.
Okay, that sounds fine. All right, so a couple of things that we need to try to figure out from the outset. What is pending that I need to make a ruling on, and what our schedule is going to be like moving forward. I know there are already a couple of weeks that the jury has been sort of told you'll be excused for this week, so I will honor that. But I need for us to try to be efficient with the jury's time. So whatever we all need to get sorted out in the interim before we bring them back, as much as we can do, I'd like to do that so that we can minimize the times when they're here, but we have to send them to the jury room to figure out things that we could have figured out before. And I know sometimes that is going to be unavoidable, but to the extent we can avoid it, I'd like for us to talk to each other beforehand, give each other a heads up about what is going to be coming in or what we think might be an issue, and deal with it without wasting the jury's time, basically. So Mr. Steele, on behalf of Mr. Williams, sent me yesterday a list of what he believes to be pending motions that still need a ruling. And I think I have one that I know of from Mr. Huey, and I'm just going to kind of hear from each party as to what, as the state as well, as to what y'all believe is pending that we need to get heard. And since I've already got Mr. Williams' motions written down, I'm just going to make sure, Mr. Steele, that I've got all of the ones that you believe to be pending. So I saw in your email a July 8th and a July 9th motion to recuse both Judge Glanville and Judge Krause, which I'm obviously, we're not going to do anything substantive here today. I'm just going to make sure I know what y'all believe to be pending. A July 10th motion entitled for a fair trial that is essentially to find out about whether there have been any other ex partes. A July 1st motion that's kind of a proffer about something that happened with a jail call, evidence that's already been taken care of. And I mean, I'll look back into that. But a July 18th motion to disqualify 2 of the prosecutors. A July 10th motion asking, I guess, prospectively for a fresh look maybe at 24-8-801. And then you had also provided an amended witness list and a notice of filing. Are there any other pending motions for Mr. Williams that I didn't include?
It's not a motion that filed. May I address that just for your edification?
Sure.
Okay.
And are you gonna file it? You're just giving me a preview, or?
I could file it.
Okay.
I'll do whatever the honorable court desires. So I just want to bring to the court's attention to be, fair to the
okay.
court. May I approach, Your Honor?
Yes. And it may be easiest to just hand it to Ms. Percefield.
What y'all think still got some?
And y'all, it's on my mind right now. Before we all leave here today, I want to make sure that my staff has cell numbers for everybody. Okay. All right.
Still about to bring the heat, y'all.
This honorable court's co-worker and the state 2 cases, PROPST versus Morgan, MORGAN, and it's 288 Georgia 862, 708 Southeast 2D 211. And if you look at page 2 of the copy of the case that I've handed to this honorable court, and the state on the left-hand side, on the bottom last paragraph, our highest court explained that another line of appellate decisions holds that if a party files a motion to recuse a trial judge and the motion is denied, but it is later determined that the judge should have been disqualified to act in the case, all proceedings after the filing of the motion to recuse are invalid and have no effect. And the reason I raise that is, Your Honor may be aware but may not be, the Honorable Douglas Weinstein filed an initial motion to recuse Judge Glanville. He did that on June 12th of 2024 in the afternoon hours. Judge Glanville initially denied, he stopped proceedings and he denied that motion without referring it to another judge, and he made some findings of why he's denying it. On behalf of Mr. Williams, the Honorable, yes?
Was there a written order?
He did file a written order.
June the 14th.
Okay.
2 days later.
All right.
And that was the Honorable Douglas Weinstein.
Okay.
The Honorable Keith Adams and I, on behalf of Mr. Williams, then filed a motion to Monday, June 17th.
Okay.
But the way I understand the case law is that once Attorney Weinstein filed that motion, which the Honorable Judge Krause eventually granted. Judge Krause, in a written order dated, I'm going to tell you, July 15, 2024, granted Mr. Williams as well as Mr. Kendrick. Mr. Weinstein represents Mr. Kendrick, both of the motions. So the way I understand the case law is everything that happened after the filing by Mr. Weinstein on June 12, 2024 is invalid.
Okay. So if you would do me a favor and put that in writing and file it as a motion, and then I will add that to our pending list.
Yes.
And I don't want to, I appreciate you letting me know. I don't want to get into substantive argument about anything today because we don't have the parties themselves here. This is basically just a sort of status. So if you will file something to that effect, then I'll have that added to the list, but I appreciate that.
I'll file it today. Can I add one other thing just for your knowledge? But
sure.
If it's something that's more than a status, then I will withdraw it.
Yeah, and I mean, you can tell me, but I'm, not going to consider it. We're not going to argue it. But yes, absolutely. Go ahead.
Understood. I just want you to know that there was a witness testifying. That's why I thought it's important, which will potentially, if you determine it, require the jury to have their notes, if you require it, taken away, and then wiping out what they heard. I just want you to be aware of that.
Okay, I'm not sure if I follow what you're saying now.
So there was a witness testifying. His name's Mr. Copeland.
Yeah.
After Judge Glanville denied that motion, the jury heard from a witness on the afternoon of of June 12th, June 13th, June 14th, and then June 17th. So I just want you to be aware.
All right, I understand what you're saying now. All right, thank you.
Other than that, those are the motions.
Great. Okay. For Mr. Huey, I have got a renewed motion for bond. Is there anything else for, I don't even know which party I'm looking at yet, but. Okay.
For Mr. is Huey. That is the only motion that I've
Okay.
at this point.
All right. Yes, thank you. Okay, so for Mr. Stillwell.
So, Your Honor, the way that we had been operating under this case, under the Honorable Judge Glanville was.
Your Honor, the way that we had been operating under Judge Glanville was there was a thing we named the Harvey Rule, which assumed that all were in agreement and opting into a motion unless we specifically opted out of the motion. So
Everybody's joined on everything.
Steele has filed a number of motions that we opt into. And Your Honor, I'll also just point out, there's also the gentleman who's on the stand right now. I think that we need to have a hearing regarding the admissibility of his testimony. I'm not looking at Mr. Steele's motion, but I too believe that we need to look at the co-conspirator exception to the hearsay rule and determine if that applies to the gentleman who is currently on the stand and what he said.
Okay.
And additionally, after Mr. Weinstein's recusal motion, we spent a significant amount of time going back and forth about prior statements and redacting prior statements. And I believe that
prior statements of Mr. Copeland. Okay.
We would have to go through that process again because that was done after the Mr. Weinstein's recusal motion. So we probably need to relitigate that as well. Of course, if it doesn't fall under a hearsay exception, then we wouldn't have to do that. But
okay.
I don't think she's touching bond today, Susan. She said she's not making any decisions today. So I don't think she's making any decisions today, y'all. She's just trying to get caught up on where everything stands.
And with regard to the question of the admissibility of Copeland's statements under the co-conspirator rule, is there a pending motion or was there an oral motion? Has there been a ruling?
There was a ruling.
Okay.
I don't recall if it's been reduced to writing. I'm going to assume it was. But you know, we've litigated a recusal motion. We've talked about the appearance of impropriety at this point, and from our stance, we need to relitigate.
Is that my computer that's buffering, or is that their system that's buffering?
Into substance, but just to educate.
But is that what you're saying should be reconsidered? Okay. All right.
Y'all do me a favor, hit the like, please. Hit the like, please.
All right. I am not going to go back. I mean, this case has been going on for how long? 6 months, at least the trial part of it. And obviously I'm parachuting in and I'm just going to have to pick up from here and move forward. I cannot go back and reconsider every evidentiary ruling that's already been made. And I don't think that's what you're asking. I think you're saying because this witness is still on the stand. But I don't know, Mr. Botts, if you were about to say, let's reconsider everything, but we're not going to be able to do that.
Just all the rulings on
Mr. Copeland. Okay. All right. All right. And let's see, for Mr. Ryan, and I understand everybody's basically joined in on everything we've already.
That's wild, y'all. Looks like it's
talked about. Is there anything that's individual or in particular to your client that I need to think about?
Yes, Your Honor. And hopefully the state will correct me if I have it correctly. But some of what specific evidence the state plans on using witness has been specified somewhat on a rolling basis.
Okay.
I'm going to give an example. In Mr. Ryan's case, there are 15 recorded interviews.
Mm-hmm.
The state is not necessarily going to offer all 15. Within the ones they might want to offer, there are parts which are inadmissible. Everyone would agree they're inadmissible, but the state has not had a chance to sit down and specifically say, we want these statements, and here's what needs to be redacted, and go back and forth on that. So we've not crossed that bridge yet for Mr. Ryan. When we do, you'll have motions.
I don't know who she is, Susan.
Okay, so I'm going to try, and we can maybe get to that in a minute, but I would rather everything that should have been a motion in limine get sorted out. I don't care if we're 2 months from that testimony. But
that's absolutely fine, Judge.
Yeah.
Describe it on a rolling basis is what.
Yeah, well, to the extent we can stop that, we're going to try to get everything done beforehand, but we'll see. We'll see. All right, thank you. And then who else have I still not heard from? For Mr. I will, y'all, in a couple of weeks, I'll know all of this, but I just honestly have not been following.
Yeah, y'all, this
case
trial's
up
going
until
forward. She's talking about in
now.
a couple of weeks. So she's not
Mr.
even
Harvey,
thinking
for
about
Mr.
declaring
Nichols.
a mistrial, y'all. Check it out. In a couple of weeks. In a couple of weeks.
And I may need you to yell.
This thing is going forward, y'all.
I'm sorry. Better?
Yes.
Per the rule we've been operating under, we're all in on everyone else's motions, barring a on-the-record opt-out.
Okay.
So we're in on everything because we have not opted out as of this point on any of those motions.
Okay.
There may be, I to be honest with the court, I wanted to see where we were today, what our plan was. There may be some additional motions that would be filed on behalf of Mr. Nichols and perhaps other defendants. If we're going to view this as sort of a logistical status conference, based upon prior proceedings, we've mentioned certain things, we've mentioned certain cases about what may or may not be valid or evidence post motion to recuse. There may be some additional motions that need to be filed. So I would ask that on behalf of Mr. Nichols, that not only we're opting in, and we need to now think about whether or not there's going to be any specific opt-out, but to give us some time frame to file any additional motions based upon the unusual proceedings and circumstances in this case moving forward.
All right, so I'm not going to be able to give you a blanket, hey, you get X amount of days to file whatever you want here, because I don't know what it is that you might be contemplating. And frankly, there have been, at least a week and a half that's gone by since whatever the ex parte was that caused all of this. It may be that it's appropriate for another motion to be filed and be considered. It may not be. I'll kind of have to wait and see sort of what it is and why it is only now that it is going to be filed. So I just can't give you an answer on that before I know what it is. But I mean, I'm certainly not precluding anybody from filing. I just don't know if it's something that could have been filed 10 months ago, then I probably don't want to hear it now.
No, I think these circumstances are unique, clearly. So it presents unique opportunities to now move the court now that we have a court. I just
why don't I just say that if you are contemplating anything, contemplate it quickly and get it filed
5 business days?
Before the end of next week, because, and I want us to all look at a calendar in a few minutes, but, the jury has already been given the week of July 29th off, so they won't be back before August 5th, really.
Oh my gosh.
So I would like for us to, if we're going to be moving forward with this case, to be able to move forward with it and have all of whatever this is going to be out of the way before then. So if you can honestly, because I would also like a response from the state on anything that gets filed. So if y'all can, given that you've had already, a week and a half since whatever went down, but you don't really need 5 more days to think about it. I'd like y'all to get anything that you're going to filed by the 23rd, which is next Tuesday. That may make for busy weekends for y'all, but that is what it is. And then I want responses from the state by that Friday, the 26th. Okay? Which does not mean I'm inviting them. It just means if there are some necessary ones that we need to consider. Obviously, I want them briefed by both sides. And then we'll probably spend the week of the 29th we'll all be here without the jury trying to get as much done as possible, I think. Okay?
And that may answer my next question. I know that on behalf of myself, and I know various other co-counsel, as soon as the words "we're in recess" were uttered, I have emails, specialists at trials. I am inundated by other, both federal judges and Superior Court judges. I am asking for protection, and I would assume that our co-counsel would join in this protection so that I can say to these other judges, I am on trial, I'm required to be participating in this court, and you cannot set me for trial in another court because I'm on
trial. Y'all
see
how this is messing up everything? It's extending out to even other trials
even need that because we are in the middle of a trial. I don't care whether the judge has changed or not. This trial is ongoing. But yes, to the extent that any judge calls at my chambers Yes, I will tell them, sorry, you can't have Mr. Harvey right now. I've got him.
I want to make those representations in conflict letters. I want to make sure that I'm doing that properly.
Yeah. Now, if there is, because I have been until recently one of the people trying to get a hold of all of y'all for other cases. So
Check
if
that
we
out,
decide
y'all.
we're taking a 2-week vacation in August, which we won't be, but you know, hypothetically
2-week
speaking, and
vacation.
y'all aren't in here with me litigating something, then I'm probably going to say you're available, not for a trial, but for, you know, a 1-day hearing or something.
Yes,
Yeah.
I don't mind the
Okay.
1-day hearing. I do mind going to trial when I'm
Sure.
on trial.
Yes.
So with that,
Y'all are all protected from
Y'all,
being
she
expected
is
to be
sitting
in trial
down and
anywhere
ready
else
for the
until
long
the
haul on this. She
end
looks
completion, however it completes, of this trial.
thank
Yes.
you. Thank
she
you.
looks a little bit giddy to be on this, doesn't she? She like, yeah, let's do this. I'm ready.
Your Honor,
She's
Doug
ready for
Weinstein
this.
For Mr. Kendrick. We have no pending motions other than what has already been stated by our
Okay.
defense counsel that we all join in. We will be filing motions before Tuesday, but we have no pending motions. And you said we are going to discuss calendar moving
Yes,
forward?
yes, yes,
Okay, I have
yes.
some comments with regard to that.
Okay. All right. All right. Turning to the state, are there pending motions by the state
All right, y'all, let's
that
see.
need a ruling?
Everybody saying love is subdued
Thank
now.
you, Your Honor. There are, and we will have to the court before Tuesday of next week, as the court has made a deadline. There are responses to recent filings by some of the defendants that the state anticipates it will be making in limine that we will have filed by Tuesday.
Okay.
Based on the court's earlier instruction today, there were matters that are more appropriately placed within a motion that we will have to the court by Tuesday as well. There are, and we will identify all of the ones that we believe exist. There are outstanding, there are rulings that have been made long ago by the court that may not have been reduced to writing. We are working towards identifying each of those, as well as putting into a chart for the court a list of the motions and rulings that have previously been entered.
That would be fantastic, because while y'all all know what the rulings were, I do not. So yeah, a chart
Y'all check
and
that out.
some further information would be great. That was on my list as well. Thank you.
Of course. And we also intend to address, we can do that in the context of a motion, or the court, if it is appropriate today, can address it. We would like to present to an exchange with counsel for each of the defendants what we believe and what we have kept a record of, ruled on and admitted so far.
Okay.
If that is more appropriately addressed in a motion, I can do that, or if the court will
Why didn't Glanville write it down?
permit us or schedule for us a deadline by which to exchange
why
exhibit lists,
Glanville isn't
because the
here.
state currently has an exhibit list that we believe is thorough.
Okay.
That includes the exhibits that have been tendered and admitted by both the state and each of the defendants.
Okay. And do you have that like with you and ready right now?
No, we want to present that to the court.
Okay.
We want to compare it with, if the defendants each have one, compare it with those. We want it to be as accurate as possible before we present it to the court.
Okay. So do y'all want to maybe, it sounds like outside of a proceeding, y'all all get together and do that? Or, I mean, if we want to all do it in court, that's fine, but it's not a bad idea.
Yo,
I would
Julie,
have preferred
yes,
that the
this
court
is
just ordered that each of us
crazy.
present to the other the exhibit list that we have, to the extent that they do exist, and that we then endeavor to iron out any differences or discrepancies. So that, for example, by next Wednesday, we each give to each other what exhibit lists that we have, not anticipated exhibits, but the ones that have already been admitted and ruled upon, because there have been moments where exhibits have been shown to a witness or spoken on, and the tendering party represented that the exhibit had already been admitted, and upon closer inspection, the exhibit had not been admitted.
Okay.
Julie, she doesn't have time to read all that. That's the problem.
From the court.
Okay, so when can you have yours ready to dole out to everybody?
We can have ours ready by Tuesday if we can exchange them by Tuesday.
Okay. Is it? I assume everybody's been kind of tracking
Well,
this.
it's Ms. Love's time to talk,
have
Julie,
what
so-
you think is the state of
both
the
sides are getting
evidence
their
by
chance.
Tuesday?
I don't think that's going to be hard to do if it's okay.
I mean, frankly, whatever the court reporter has is what's accurate. So it might be that I can just get that list from the court reporter and give it out to all of y'all.
New court reporter today too, y'all.
And if there is that might be a better way to do it. And then if there is a discrepancy and anybody believes that's inaccurate, we can take it up. So why don't I talk to Ms.
Yes,
Parker, but Ms.
geez.
Parker is retiring in 1 week. I will have a new court reporter and
another court reporter.
I know. It's the end of an era.
It's just musical
I'll have a new
chairs
court
in this
reporter,
court.
Ms. Winfrey, who probably a lot of y'all know anyway, and she'll be moving forward. I'm going to ask Judge Glanville's court reporter to start working on transcripts because I'm going to need them, but we'll all need them at some point probably, because just transcribing what's happened so far is going to take months and months. So we're going to shift not only judges, but also court reporters. So I will get with Judge Glanville's court reporter and ask her to give me a list of what has been tendered and either excluded or admitted or is still hanging out there. Give that to all of y'all, probably just through email from Ms. Rosser. And then if there is any discrepancies, y'all can let me know that, okay?
That would be great. Does the court, and I understand that there's really no way to tell accurately, but does the court have any idea of when we could anticipate receiving something
I think pretty quickly. I mean, I've had a couple of communications with her already, and she seems pretty on the ball, and she's tracking it all on an Excel spreadsheet or something. So I don't think it'll take long. I think I can get y'all that by next week.
Yeah, Miss
sometime.
Weaver about
Thank
to
you.
clock
Okay.
that double OT,
Let me
that
write my
double
to-do
time.
list. Okay.
Yeah, it's better to get it from the court reporter. People are saying they don't trust her because she's a Glanville. She works with Glanville, but I'm sure she's a professional and she'll do a good job. Y'all, this thing is about to continue.
Your Honor, I'm reviewing all of the notes from representations made by counsels for each of the defendants, and based on my review of those notes, I don't believe that there are other matters that we need to address at this time that are properly addressed without the defendants here.
All right. And do you have an idea of when you can get me the list of the rulings so far?
Yes, Your Honor.
And I know that's a bear of a task, so
Now-
that's okay. Don't want to be
like Miss
unreasonable
Weaver?
about it.
Miss Weaver was in there
1 second, because we have already
every
begun
day
that
with the
process.
scowl.
And let me, if the court will permit me to confer with
What she had to do.
our team members who are working on that.
Thank you.
Thank you.
See, what I don't get about this is this: isn't this definitely going to an appeal? If they were to lose, YSL, any of them, this is definitely appealable, y'all. Like, easily. Now, would they win the appeal? That's a different question. But, yo, this is wild. So I think.
Actually in on this case, or are you just standing in for Mr. Williams today?
I'm actually in on the case. I did file an inquiry.
Okay, thanks.
So everybody's like, what about the mistrial? What about it? She does not seem at all like she's anticipating a mistrial. Judge Whitaker's like, we gonna do this. Now, y'all, let me give you a little bit of quick information that you might not know. I heard on another show yesterday that Judge Whitaker was considered for the Georgia Supreme Court, and they were speculating that if she can come in, get this thing under control.
And Your Honor, I know that we can have that list before next Friday, or at least by next Friday. That'll be great. Okay, thank you.
She can come in here, get this thing under control.
All right.
Get it to a verdict, next round for Supreme Court.
The most immediate scheduling, the kind of getting through, hearing argument on, getting rulings on the things we all just talked about that are pending. Is everybody available and I guess I've already got y'all, unless Judge Glanville had excused you, I think I've got y'all, but is everybody available? And I'm not saying we're gonna be here 8 to 5 every day, the week of the 29th, but is the week of the 29th, everybody's available to the extent we need all of those days?
The state is available.
Okay. Anybody not? Okay, perfect. Because I'm thinking that at least most of that week, that's what we're going to be doing, which means I am not going to be going to the judges' summer conference, but that's okay. That's okay. Okay. All right. With regard to kind of further in the future, just when we're going to be having trial, I think it's maybe been like 4.5 days a week or something. I don't know. I guess it doesn't matter what it has been. Here's what I'm thinking. I am thinking that when we are in trial, we start at 8:45 and go to about 6, at least until the time change, or that all the jurors can do that. I don't know what their, pick up kids schedule is or anything like that. But I want to make the most of our time, like I said, while we're here and have them.
8:45 to 6.
So that's kind of going to be my plan going forward. And it may be that we want to go all 5 days. It may be that we want to, break at lunchtime on Fridays. And if we have other business to do, we stay for the afternoon. We may have so much left to do still that
sorry
we
about
give
the
them another
OBS,
week.
y'all. I'm
once we do
checking
start
my
back
settings.
with the jury, I'm thinking 8:45 to 6. And when I say 8:45, I mean 8:45. I intend to
I like that.
take the bench at 8:45. I expect I know that the parties, the defendants will be here because the sheriff's office will have them here. I want all the attorneys to be here as well. And if you have 5 attorneys on your side, as long as one of them's here, we're going forward. Okay? So I don't want to be waiting around till 9:30 to get started. 8:45.
8:45.
All right, so things have been brought to my attention that some people might like changed now that have a fresh face. And y'all, some of these are really kind of insignificant, but I'm gonna go ahead while we've got some time and bring them up. Food in court. Everybody can have water whenever they want to. The attorneys can have, whatever drink they want to, as long as you're not klutzy like me and don't spill it all over everything. I guess if you do, that'll be your problem. If we are working through lunch and the jury's out and we're working,
Yeah, Matt Spiller, she looks
are here
organized.
And the clients are here, that's okay. But snacking while trial's going on, we're not going to be doing that, okay? So if we are working through lunch, if we are working late and it's dinner time, it will be okay to the attorneys or the defendants have food. Not while somebody's on the stand testifying, okay? We're not at a movie. We're not going to be eating popcorn. All right. Hopefully that'll be all I have to say about that. Apparently, one of the first things that I don't know how many different deputies told me was the clothing for the clients has gotten a little out of hand in terms of how much they all have now. I don't know, but
dress code.
Y'all need to maybe get together and let's exchange most of that. And sure, they can have new outfits for court, but
dress code, y'all.
It sounds like they're like full wardrobes full of clothing for some of these defendants, and that's just a lot for the deputies to have to keep up with. So how about if y'all check in and maybe through Miss Rosser, y'all all know Miss Rosser, I think. She's not even here today. Yes, she is.
One outfit per
Miss Rosser,
person.
my fabulous litigation manager. And let's make sure that it gets whittled down to a manageable amount of clothing, like there are only going to be 5 days in each week. So even if they had a different outfit every day, that would only be 5 outfits, okay? We shouldn't have 20 different outfits for anybody. So y'all need to clear out, apparently, the closet. So now I've done that for the deputies. They'll be more happy. Okay, next topic.
It's getting good now.
Minimizing disruptions in court. I don't exactly know what that means yet, but let's try to conduct court in a way that minimizes disruptions. And we'll just leave it at that for now.
No cell phones ringing.
There was an issue about apparently, and I'm not even sure if I understand exactly what has gone on with this, but the defendants listening through earpods to things on laptops while court is going on. And I'm not sure I understand why that's happening, and that raises some security issues with our security staff, with the sheriff's office. To me, what that's about and why that's necessary. And if nobody wants to, then we'll just do away with it.
Max Sharp back there smiling. Y'all see him?
I think it was originally combat boredom.
All right. Well, we won't be bored from here on out. So then if that's the only reason for it, I want to be moving forward.
Yeah, somebody snitched, y'all. Somebody said, hey, this is what they've been doing.
Let's just plan to not have that happen anymore. And if there arises some new reason for it, then we can address it again anew. Okay?
She has some notes.
Yes, sir.
Good morning again, Sergeant Matthews, Mr. Huey. There are times where the defendant might need to listen to evidence, interviews, things of that nature. And I've made that available for my clients to listen to some of the interviews from witnesses, testimony,
combat
prior interviews, things of that nature. For evidentiary purposes, that would be a request for my
his brother knows what he's talking about.
Have that access where necessary.
So why is that happening in court? That seems like something that should happen after hours between the two of you.
I certainly understand that. Just maximizing the time that I have with my clients since I don't have availability with them outside of court every day. So he's here, we're here. So a lot of times I'll give them an opportunity to review evidence and things of that nature.
There you go.
The only reason I want to ask.
That's a good.
I'm going to ask that you try to get that done outside of courtroom time. And if there is some sort of an emergency, unexpected reason why something can't have been reviewed before, then you can bring that to my attention. But okay. All right. I would like to find out from kind of everybody how many witnesses there are to go and what you expect those witnesses to say. And one reason I say that is because Judge Glanville had entered an order, which I may not have brought downstairs with me, but y'all, when I describe it, will probably be familiar with it, that essentially said everybody, not really, but several parties have asked for mistrials, I think, because things are moving so slowly. And he entered into order that seemed to say, it appears that the state has 200 and something witnesses. We're on 50 something now. Everybody's causing disruptions, or not causing, but there have been a lot of disruptions because a witness is on the stand and all of a sudden one party or the other comes up with some video that nobody's ever seen before. And that's the reason for all of this disruption.
All right, y'all.
But
How
at
many?
the same time,
What's the state going to say?
know,
How many witnesses do they have?
maybe some of this can be whittled down, and that is a wild paraphrase of that order, but I think y'all know what I'm talking about. What I want to know is, where are we really? I mean, I know, witness lists look one way before the trial, and who you end up calling oftentimes ends up being something different. I know this is a multi-count indictment. I know that there are a lot of defendants involved in several different incidents. And I don't expect this right now, but I would like from everybody, to the extent the defense knows whether they're going to present a case or not, a realistic list of witnesses, maybe like what counts they go to and what you expect those witnesses to say generally, broadly. Because this case has been going on for a really long time. And there is a rule that lets me exclude cumulative evidence. And I might end up using that. So how about y'all give me a heads up on all of that, okay? And if that is something that y'all could have to me by next Friday for everybody, that would be great. Let's see, what's next on my list?
I feel like they need to be higher on y'all.
With regard to kind of just general scheduling, other than the week of the 29th, and then I was told, I think Monday through Thursday of August 19th through 22nd. Is anybody aware of time that has already been given to the jury as you're out of court this week? You have this week free? No? Okay. All right. Does any attorney right now know of a date that nobody from your team can be here? And I wouldn't expect that to be the case because y'all are in trial, but no, I mean, anybody getting married? Okay. So I hesitate to even say the next thing I'm going to say, but I'm going to say it anyway. The little bit I have seen about this case, it definitely has appeared that there have been times that tempers have flared a whole lot and that people have been maybe less than professional. And
Straight
I
disrespect.
hope that this kind of breather has given everybody a breather, and everybody has been absolutely wonderful here today. But I would like for us to maintain a degree of decorum and dignity and professionalism. That is what is really expected of all of us as members of the bar. I don't want to have to say anything beyond that, okay? But if it gets to a point where I think that is not being carried out appropriately, we're going to all have to talk, okay?
Threats.
All right, what else do y'all think that I need to be thinking about, or do we need to be talking about, or at least raising to talk about? Anything from the state?
Your Honor, I believe that the court has sufficiently addressed everything that we had anticipated we needed to address with the court.
Okay. All right. Mr. Weinstein?
No, Your Honor.
Okay. Mr. Sharp, anything?
There have been,
this case, as you know, is enormous, and the discovery is enormous. There are certain, with Judge Glanville, we have some general rulings about some matters, but not particulars.
Okay.
I'm trying to give a heads up. This is an example, but I don't think it's regarding, there was a wiretap in this case.
Okay.
And the judge overruled my objections and stated that the wiretap was legal. He made that finding. However, there are other issues about the wiretap and the particular things said in the wiretap. Some of those pieces of communication may be admissible, may not on an individual basis. Certain things like that, I'm just giving the court a heads up, have not been parsed through to the particulars.
Okay.
And we've discussed like the need to do those things, and some of those things we've kind of kicked the can down the road a little bit, so they're still outstanding.
Okay.
I just wanted to bring it to you.
All right. So maybe when everybody is putting their lists of witnesses and what they're generally going to be talking about together, they could also, I don't know what happened to my mic all of a sudden, they could also include if there's any kind of either voluminous evidence, video evidence, audio evidence that we need to be considering admissibility of before the witness testifies. If y'all could maybe list out for everybody what that is, because yes, I absolutely want those things to have been determined before, witness Smith gets on the stand and we have 18 hours of some kind of video statement that nobody's thought about yet. I'd like to say I'm sure that all of the evidence has been exchanged by now. Would I be correct in saying that?
Why she laughing a lot? Isn't
reports
she?
that we're still missing.
I wonder if
State
that's her
has said that
style.
they don't have those reports. Officers have testified that they wrote the reports.
Okay.
And we're still missing.
All right.
That's been a recurring theme.
All right. If everybody wants to detail anything that they think is missing, and I'll hear from the state on whether it is either missing, about to show up, or does not exist, that'll be something we can take up substantively, just so we start out all on the same page. That'll be something maybe y'all can do next week, and we'll take up the week after that as well. Okay, because if we need like 5 days of motions in limine, we need to do that. Okay.
They saying love
Judge, I just wanted to
is heated.
it has complied with its discovery obligations, and we have turned over all of the discovery that exists in this case. And as the court is aware, discovery is that which we have so we have turned that over, and we've actually gotten and requested. We've sought from outside our office any other materials that existed in the universe. We will do as the court has instructed and provide to the court a list of matters we believe have been unaddressed still as they pertain to our requests for reciprocal discovery.
Okay. And Mr. Shard, I know you've been in my courtroom before, and typically I have, one side or the other list out specifically what they think is missing, and we inquire about it and try to get to the bottom of it. So that's what we will do. Y'all make up the list, and then we will do that. We'll actually go through it in detail so that everybody knows what's going on and we all are on the same page. All right. And y'all, for any evidence that there hasn't been a ruling on yet that I'm going to need to consider the admissibility of, I obviously am going to need a copy of that. So if I've got 5 hours of some audio to listen to, I don't want to listen to that in court. I want to listen to that beforehand so that I know what we're talking about before we get to court to hash it out. So get me all of that as well. And that'll be more homework for me to do.
Y'all hit the like for me, please.
Okay.
Just hit the like button, please, people.
So let's
Thank y'all.
go
Appreciate
through
y'all.
anything, either Mr. Williams or Ms. Sabashi for your client. Okay, Mr. Harvey, Mr. Steele.
No, not
Okay.
this time, Your Honor.
All right. Okay, the next thing I want to raise, and I have no idea what has happened before now, but I would like to encourage everybody, while we are kind of in this pause, to talk to each other about whether there are any plea negotiations that might be fruitful, whether there is any room for movement by anybody on anything, any plea. I mean, I'm willing to entertain any kind of plea at any time. It can be a joint recommendation. It will be non-negotiated since we're in the middle of a trial, but it can certainly be a joint recommendation, or it can be state wants this, defense wants that, or it can be we all want to keep going with this trial. I am here to give everybody a fair trial and everybody a fair shake, follow the law. But I invite during this pause, if y'all want to think about that and talk about that, now would be a good time to do that, okay? All right, so I think that y'all have a lot to do and I have a lot to do, and we will plan to get all of our filings and all of our responses in before the end of next week at the dates that I had provided.
She's not doing a mistrial.
And why don't we
right
plan to maybe not Monday, but Tuesday, the 30th. All convene here at 8:45 and just start tackling everything that got filed, okay? And we'll plan to go pretty much all day until we finish every day that week. And by the end of the week, I'll know whether we are at a spot to bring a jury in or whether we need another week. All right, anything else from anybody?
I have a question, Your Honor.
Yes.
The court instructed that we provide the court with evidence for which there may be admissibility issues.
Yes.
I wanted to ask for the court's clarification if that meant whether there have been prior motions to suppress filed, or if the court is instructing that notwithstanding the absence of a motion to suppress on a particular piece of evidence, that we are now going to be entertaining motions to suppress. For instance, if there's a recording that we have turned over, will the court be entertaining motions to?
So I don't really know what the expectation has been. I mean, if this had been my trial from the get-go, we'd have litigated all the motions to suppress by now. Motions to suppress shouldn't really be getting filed mid-trial. That being said, I would rather, if somebody is going to stand up and say this is 100% unconstitutional for X, Y, and Z reasons, I shouldn't be letting in something that's unconstitutional for X, Y, and Z reasons. So I'd like to know it, but I mean, I want it to be a legitimate, valid concern evidentially, constitutionally. I don't want it to be, here's my chance to challenge everything under the sun. So I don't know if that answers your question, but it sounds like there are chunks of evidence that everybody has just basically not gotten to yet, and y'all sort of said, all right, we'll get to that when we get to this witness. And if y'all have been operating on a kind of rolling, all right, when we get to this witness, we'll deal with that evidence, then if that's what the expectation has been, then I wouldn't expect y'all to have all filed all of your challenges. I don't know what's been going on.
Your Honor, that has not been the case. No, but because of the way that the court indicated that the court wanted parties to provide evidence regarding admissibility issues, I just wanted to make certain that I understood what the court was instructing. There have been evidentiary issues that I believe the parties disagree on. The state disagrees with counsel for defendants' interpretation of what is right and what is valid for contesting at a particular moment. I don't doubt those will continue to arise, but I was asking as it pertains to what the court instructed just a second ago regarding evidence. I didn't know whether the court was doing something different than what I.
Okay, so I don't intend to revisit rulings on evidence that's already come in. But for evidence that we know is out there and was going to be introduced a month from now with, witness Jones, if y'all been doing that on a rolling basis and y'all know that there are going to be evidentiary issues with it, things that I would have considered motions in limine, then I want us to all go ahead and voice that now and sort it out so that we know when the witness shows up what can be talked about and what can't be. And I don't know if that gave you clarification. Okay. All right, Ms. Abbasi.
Yes, Your Honor, if I may, I have to disagree with Ms. Love. It's been going along that we've already had motions about what is not admissible. Just to propound on kind of what Your Honor was mentioning and what the task of defense faces, we have a list of 8,000 jail calls. We haven't listened to 8,000 jail calls, and I think probably the majority of them are not relevant. Everyone would agree that they're not relevant. The state's not actually going to introduce all of those jail calls. However, defense, our burden, if we don't raise the objection, it's been waived, and then it comes in at trial.
Okay, so that's why the witness lists with what this is relevant to and what evidence is going to be used is going to be, I hope, very helpful in giving us all a better kind of groundwork.
Yes, Your Honor, that is precisely what I'm asking.
Okay.
20,000 pages of Instagram, it's going to be these ones.
Okay. Okay.
And Judge,
yes, sir, Mr. Adams.
Good afternoon. Again, Judge Keith Adams with Mr. Steele for Mr. Williams. Just to, I think the court wanted to know if there are things that Judge Glanville had been doing in regards to that particular issue. And I did want to just append to what Mr. Biden was saying. For example, there have been jail calls, there are interviews that generally speaking there have been hearings on the admissibility of those statements.
Okay.
But the court has oftentimes said, I agree that, for example, this statement may be admissible, but there may be some things in the statement that's objectionable.
Sure.
We'll deal with that.
Okay.
At that time. The court has routinely been doing that. So not necessarily kicking the can down the road, but addressing issues as they come up. And the court has urged both sides in advance of that issue coming up. If we can get together and iron some things out, let's do it. We've been working to do that, but there have been routinely times where we simply just disagree and we've had to take those items up. And I think what you would like, what Judge Landell has asked, is that let's let you know about it as far in advance as we can. That way you can set aside some time to deal with it without impinging on the juries.
Absolutely. I mean, that is, I want to be respectful and cognizant of the jury's time. I also want y'all to all know what to expect to the extent you can, and litigate everything that we can litigate beforehand, if it's going to be necessary. Now, if there's some totally irrelevant Instagram post and the state knows they're not going to use it, but they listed it a million years ago, their updated list that they're going to share with everybody should not include the Instagram post that they know they're not going to use. So, all right. So I will expect whatever filings y'all, I will anxiously anticipate all of them. Make sure whenever you file anything, that you contemporaneously email a copy of it to Ms. Rosser, because the court and chambers do not automatically get what y'all file. I have no idea what you filed unless you actually let us know. So make sure that when you file it, you send a copy to Ms. Rosser so that we know about it. Okay? All right, so I'll plan to see everybody bright and early at 8:45 on Tuesday, July 30th. All right? Don't leave until you make sure Ms. Rosser has your cell information.
Can I
All right.
question?
Yes.
Judge Glanville had,
You
for both
still had to
sides,
get on there.
2 Fridays before that tell the other side what witnesses and what exhibits are going to be in play. I would hope that continues. That would be very helpful.
That sounds like a good idea. So sure, we can leave that as sort of a standing rule. And I suspect that this is true as well, but let me go ahead and say that as we're going through trial, I expect you to have your next witness ready to go. I don't want there to be a 5-minute pause between one witness getting off the stand and the next witness getting on the stand. And the state knows, we're in the state's case right now. The state knows what it's doing. The state has investigative help. Make sure you have enough witnesses to carry us through each day and that they're ready to go. Again, that all just kind of falls under the auspices of let's be respectful of the jury's time. Mr. Harvey.
Can I assume, Judge, that we are going to continue with the opt-out rule so that you're not going to get all 8 of us standing up going, I'm in too?
Yes, no, that's a great idea. Let's continue with that rule as well.
Thank you.
I mean, I plan to basically continue with the rules already in effect unless there's some reason to change them. So I hope if there is something, y'all can bring it to my attention. Otherwise, we'll just keep rocking as before. All right, thanks everybody.
Excuse me, remember the press, there was a rule in place for the members.
So I guess y'all would have agreed beforehand that a particular witness shouldn't be shown on camera. And then who gave the list?
The state has been providing to members of the press the list of those persons, and the judge has made rulings regarding those.
So I saw a ruling that said if there's somebody who, for whatever reason, shouldn't be shown, whatever kind of concerns, then they won't be shown in the, but
it wasn't exhaustive.
It seemed that was kind of a witness by witness thing, and that there was an opportunity for input.
Yeah, there's an order that the judge entered, and there were certain reasons that the state could request that witnesses not be televised. I believe that was to be provided to us the Friday before, and then we would have the opportunity to get to that by Monday.
Right.
And then the judge would make a decision based on his criteria whether that witness should be shown on television or not.
Right.
And I believe that Mr. Harvey has a standing objection to all witnesses at this point.
Okay. Wait. To all witnesses being shown or being excluded? Okay. Well.
No witnesses excluded. I don't speak for Mr. Harvey.
All right.
And I'm in concurrence with Mr. Harvey.
Okay. Well, that's why I guess it's being taken up on a case witness by witness basis. So, Ms. Love, then you're providing that. If there's objection, we're litigating it. And then are we saying it's like the next Friday that we then tell the press, or help me out on that?
Ms. Hilton says she has been providing that list. I will let her explain to the court.
Okay, because I guess I'm wondering, how is there a list if there hasn't been either agreement or a decision on it?
I believe, I'll let Ms. Hilton start, because she's the one that initially prepares the list.
All right.
Good morning, Your Honor. Or
good afternoon at this point.
What has happened is the week before, certain witnesses were going to come up the following week.
Okay.
We would identify any of those witnesses that we are asking not to be shown. We would forward that to the media as well as to opposing counsel. They would then, decide, object, and we would hear on Monday the ruling from the court.
Okay, well, so then with regard to the media's inquiry, it sounds like what y'all have been getting as a list from the state is kind of the preliminary, we think this might be the case list. But Ms. Hilton, do you then give them and here's what our determination was list, or?
So normally the court has put on the record that Monday, whether or not that witness should not be shown.
Okay, so you've got your list and you either strike that person off because I said they can be seen, or you just go with what's on there. Okay, that makes sense. So yes, we'll continue with that as well. All right, we're in recess.
She was eager to get that over with, wasn't she? So was I. Not really, but brother had to get some food in his belly. All right, y'all. Well, for everybody on here, please hit the like. I thank y'all for spending this last, hour and 15 minutes with me, with PIW. Really appreciate it. Y'all saw brother had to start eating. I was hungry up in here. So I'm going to go ahead and end this live. Everybody drop any comments you have. Again, please hit the like, and we will see y'all back tomorrow. I think tomorrow we're going to do Straight Disrespect Part 3. So check for that tomorrow. Thanks a lot. Y'all have a good day.